I'm Dan Richards, talking with Ellen Bessner, a partner in the Toronto law firm Babin Bessner Spry, a leader in the area of regulatory and litigation defense for financial advisors. And Ellen, this is one of a number of conversations that we're having. This one focuses on the downside of preparing a financial plan for clients and one specific case around that. So tell me about that case.
So it's the Geisbrecht decision. It went to trial and in the Court of Appeal. The facts of this case are Mr. and Mrs. Geisbrecht were in their 50s and basically hated their jobs. And they wanted to know, if we need $35,000 each year for the rest of our lives, say, assuming we live till 90, how early can we retire given the assets that we have?
So the financial advisors they were talking to, now these were existing clients or prospective clients?
So these were an interesting question. They were existing clients on the insurance side, but not on the mutual fund side, because these guys were dually licensed.
I see.
So they had given them insurance advice on some certain insurance products, and now they were putting on their planning and mutual fund hat to see how they could help these clients further.
And they created a financial plan, is that right?
They did. So they said, given these certain assumptions, including your nest egg is placed into our accounts for mutual fund investments, that you make regular deposits, and they estimated how much that would be, and that there was certain money coming into them that they anticipated, assuming all of that would happen. And assuming that the returns on your investments were, and they gave them a couple of scenarios. So we say that you could retire by a certain time, depending on whether all the stars align. So they give this document to the Geisbrechts, and the Geisbrechts put it into a drawer and ignore the document. And unfortunately, the advisors also, when they meet with them, they don't bring it to their attention and talk about, well, do we need to revise this thing? How's it going? Have they followed the things that they said they would do right at the beginning, which they didn't? And so basically, both parties ignore this document, and it goes into a drawer, and we're done with it. But the Geisbrechts then think, oh, okay, well, I think we're going to retire now, because one of them gets a package and the other one decides she's going to quit her job. And so they then decide they're going to move, and instead of renting, which was part of the plan, they were now going to buy another house. So they were way off their plan. And one day they wake up and they turn to the advisors and they say, we think we're going to run out of money. And the advisors say, yeah, we think you will too. We think you better go back and get jobs. And so they go back and they get jobs, and they sue their advisors for the money they lost during the period they weren't working, saying, well, we were relying on this plan, which they really weren't. Right. So they take it to trial because, they're suing them for this money. They take it to trial, and the Geisbrechts win because the trial judge says, advisors, you prepared this plan, and you were negligent by not raising these issues. You had been meeting with the clients over the period, and you didn't raise these issues with them. You knew that they had quit their jobs. You didn't bring the plan out, revise it, and make it clear to them that this was no longer going to be the plan. So they lose a trial, and they appeal. And the Court of Appeal said, I don't think so. We're overturning the trial decision because the clients knew what the situation was, and they went off on a frolic and did something completely different.
And so the clients, in fact, have some responsibility here.
The clients have responsibility here, no question. But here's the problem. Ultimately, these poor advisors had to deal with this trial. The stress of the trial and the stress of winning the appeal and the cost associated.
And the reputational risk.
The reputational risk, the fact that their other clients see it's all public.
Right.
That's a big price to pay. Right. So the key is you never even want to be sued by clients, even if you win.
And so the real message here is that when you create a financial plan, whether it be at the client's request or at your own initiative, that you have an obligation. There's an implied obligation on the part of the advisor.
So the implied obligation, or maybe even not implied, maybe it's really just the obligation, is to make sure that the document says, these are illustrations and these are assumptions that we're making. This clearly is your bailiwick of things that you need to do, and this is ours. And then when we meet regularly, we're going to pull this document out and we're going to make it real, and we're going to adjust it. Oh, you lost your job. Oh, you got a package. Oh, you couldn't stand another minute at that place.
And if a client says, look, you know what, I just don't have the time, I don't have the interest, I'm too busy, I don't want to spend the time to update or review that financial plan, then what's the advisor to do in that scenario?
The advisor then should put something in writing to the client saying, we have developed this plan, but we're clearly offside. You've indicated that you don't have time to update it, and I understand your circumstances have changed. More than happy to meet with you at your convenience, and I understand that it's not convenient for you now. So please let me know when it would be convenient for you. And then each time they meet, they should make a note. Discussed with client, updating of plan, client didn't want to spend the time. You need a real paper trail to protect yourself.
So the message here is that once a financial plan is created, or even something that may not be a financial plan as we understand it, but is called a financial plan, that there are then some ongoing obligations for financial advisors from that moment forward.
Yes, and they should be very aware of what those are.
Ellen, thanks for talking.
Thank you, Dan.